another welcome to everyone. We have well over 100 people joining us this afternoon for this really special occasion. I'm going to show everyone at this point. Thank you, judges, for keeping your cameras on. Everyone else can feel free to turn their cameras off and to please stay on mute. Feel free to use the chat for any comments that you may have throughout. The questions that we have prepared for the judges today have come directly from the cross-agency or cross-division trauma initiative. So in our meetings, we ask folks to generate questions, and we have 10 today. So we're going to go one through one. I'm just giving a quick snapshot here. I will not read them for everyone because we are going to go one through one. So these are the first 5, and these are the second 5. Myself and 2 of my closest colleagues from our center, Dr. Cassie Kissel and Kaylee McGrath, are going to be taking turns posing these to the judges. I was teasing the judges earlier that I know we could probably have a 24-hour webinar where each of them talk at length about the responses to all of these questions. But in order to get through all of the questions today, we're going to try and keep each judge's response to about 3 minutes per question. So please bear with us as we progress through today. And I want to welcome all of the judges to be as informal as you are comfortable being. This is a give and take. If you're not assigned a question, but something jumps out to you and you want to share, by all means, please do. If it's your turn and you feel like you'd like to pass, please feel free to do that as well. Whatever works for you works for us today. So here is our first question that we are putting out for 3 of our judges. Judge Bonfiglio, Judge Tepper, and Judge Reddy. How have you personally incorporated trauma-informed care into your courtroom? So maybe Judge Bonfiglio, since your name is listed first, if you wouldn't mind.
Sure. I think the reason I wanted to respond to this question is to start telling you about our courthouse. We've certainly been trying to incorporate trauma-informed care in our courtroom, but we had an opportunity starting in 2019 to look at constructing a new facility. And I had the very good fortune of having Judge Tepper actually presented to our judicial conference in 2021. And that was at the height of beginning our process of designing a new courthouse. So my first question to the design team was, okay, we need to have folks that are going to be involved in the design team that understand what a trauma-informed courthouse would look like. And so we went through that design stage. We went through building, and now we have implemented. We actually moved into our new courthouse in September of 2025. And we have designed the courthouse with trauma in mind. There's our design team included an agency that specializes in courthouses. They understood immediately when I asked the question. So we have a very spacious courthouse with lots of open spaces, lots of natural light coming in, warm, inviting colors. Our hallways are very simple, straight, open. There's no hidden corners. Our acoustics are reduce noise. We have our family courtrooms are designed to be small enough to be conversational. When we started looking at courtroom designs, we looked at they showed me these crescent-shaped tables for parties to sit at. Well, there's a place for everybody. We have crescent-shaped council tables or party tables. We have place for grandma. We have mom, dad, their attorneys. If it's DCS, their attorneys, caseworkers, supervisors. There's a place for everyone. And a much more conversational room. I've had many traditional courtrooms over the years, actually rooms that were designed for other purposes. This is the first courtroom I've had that actually designed for court. And it has made a tremendous difference. We've also have accommodations for children. We gave a month long of tours to the community, and we had many children would come and visit. We planned for kids to come, and it's very apparent that we have special places. We have some pergolas in our public hallways. We have toys, we have books that children can take with them. We have courtroom areas for children to play actually in the courtrooms. Again, Judge Tepper was very much my inspiration, and having had her wonderful presentation a number of years ago, was able to actually incorporate in our construction of our facility how to make it trauma informed, looking at various aspects of how the actual building can actually trigger trauma in individuals. So we've tried to minimize that. We've also staffed our security force much more clearly. They've had trauma training. And when we give out notices to folks to come, we tell them about our safety issues and the ability for them to get help, or if they have a concern, let staff or court personnel know, or security staff, because they're present on the floor. We have every inch of the place covered in cameras like most courtrooms do, but our physical facility was designed with trauma in mind, to minimize the impact of walking into a courthouse.
Thank you so much, Judge. Appreciate that. Judge Tepper, would you like to take a stab at the question?
Yes. One of the first things that I found was important was how you schedule court. And mass dockets is not trauma informed. And I didn't think I needed to impose it. And so before I change any calendars, I invite everybody that's going to be participating to come to the courtroom, and we're going to do something informal. And my judicial assistant makes notes and hangs them on the walls on what they think an ideal docket would look like. In other words, we want, particularly where you have crossover cases, unified family court, I need all the players there. I don't need just the one of the attorneys to be there. I need the guardian ad litem, the CASA, to be there. I need the case manager for juvenile justice. I need the case manager for child welfare. I need to have the prosecutor there. I need to make sure that the people that need to be there can be there, and not being forced to do an intake or investigation at the state attorney's office. And so we agreed on the days that we could do all our crossover cases, and then I wouldn't have to worry about it being available. And those were set. And then we also looked at, well, wait a minute, should we really be doing our juvenile arraignment docket at 9 in the morning so that all the kids can miss school, all the parents are going to miss work? And we decided that doing them at 2:30 or 3, when most schools are out, made more sense. And then we set times when we would say, okay, let's do our pretrials or status hearings at 1:30 or 2:30 in the afternoon, and let's make sure we're setting them so that we have enough time, so that if they need 30 minutes, they have 30 minutes to cover all of their issues. And that made a big difference, and everybody was on board. And then we started doing, thanks to the recommendations of the National Council of Juvenile and Family Court Judges, stakeholder meetings. And we would learn. I'd have somebody that was a specialist in early childhood educate. They might be in person, they might be appearing, by video. We would learn about vicarious trauma. We would learn about new programs in the area. This is where your clients can get help for electric bills, for housing, things like that. We would learn about veterans programs, and everybody would hear. We did it once a month on a given day. And so we also sometimes visited programs, model programs in other parts within driving distance of the courthouse. We visit the different clubs that looked after the interest of children and families. And the other thing we did was I got the mental health program in our area to give me a liaison in court. And so then if somebody was having a breakdown in court, she could pull them outside and see if they help get them into a residential program, get them an immediate visit, things like that. And that made all the difference in the world. And then the courtroom was filled with therapy dogs, stuffed animals. We had children's books that were donated from myself and my judicial assistant until we got a newspaper article. And then for a dozen years, it never quit, and the community kept donating them. And by the way, I also keep healthy snacks, and the health department kept condoms available, and we put those on the desks as well. And of course, our courthouse is very child friendly, child waiting room, and take home books and murals. And we we made it so that you don't get lost and you're not afraid. And that if you're a victim of violence, you've already got the instructions on where you can go and wait. Thank you.
Thank you so much, Judge Tepper. We have one more judge, Judge Reddy, who's going to respond to this. Judge Reddy, would you mind?
Sure. So a majority of the cases that I spend my days on are divorce cases. I don't handle the cases with, Department of Child Services or juvenile delinquency, except in rare occasions. So it's really the divorcing families. And, I think my goal the past few years has been to really redefine how families view the court when they're going through a divorce. I wanted people to feel like the courts are not just here to be the decision makers. They're here to actually be available to help you and to provide services. Now, some people might call that judicial activism. I don't. I think that when it comes to family law, it shouldn't be an adversarial process. We should all have the same goal of how are we going to help these children. So a few of the ways is, so we've created, what we've just called a family court project. And the way it works is usually within a few weeks, but usually less than a month after a case is filed, I have the parents come to the courthouse. They don't meet with me. This is long before there's ever a court hearing. They meet with a social worker in her office, which is in the courthouse. And when they get to the courthouse, they, fill out a screening questionnaire so we get some information about them, a social needs assessment, and then they meet with the social worker just to sort of tell their version of the story of what they need help with. And then from there, and the part of the reason we've done this is I wanted to take away that stigma of it's an adversarial process, that here's a social worker, she's just here to help you. And she tells them what the Family Court Project is and says, if you need help with housing or employment skills or how to get on health insurance or, hygiene or budgeting or whatever it is you need connected with, that we have a system in place to help you do that. And so I think that's sort of one of the ways we want to sort of, recreate what this process is about. Then from there, within a couple of weeks, they meet with a family court navigator. She is not employed by the court. She is employed by a nonprofit agency. And so they go to the nonprofit agency. Again, this is the second meeting they're having before they ever appear in court. And that's, again, the family navigator sort of explains, all the different services they can be connected with. Here's all the different counseling services we have. We've worked pretty hard over the past 4 years to get funding. One of the most difficult parts early on when I became a judge is I would refer people for counseling, but they couldn't pay for it and insurance wouldn't cover it. Well, now it's fully funded. I mean, the organization does bill insurance, but we cover individual counseling, family counseling, anger management, batterers intervention, co-parenting, whatever it is, we have the funds now to cover that. I think that's helped a lot. One of the biggest things we've done that I really like is that almost every child going through a divorce, at least in my court, gets a biopsychosocial assessment. So we know very early on in a case, how is this child really doing? What services can we provide to help them? Because that's the ultimate goal. And sometimes we'll find even the parents, they will start these counseling services before they ever come to court because they know it's paid for. And so I think that's been something that's been really helpful. And that's sort of the way I think that we've viewed trauma-informed care. We've got an old building, so we can't really change the structure. I like all the ideas I've heard, but I've really focused on services to try and get people the help that they need.
That is fabulous. Thank you so much, Judge Reddy. I believe, Cassie, you're going to navigate this next question. I'll move the slide for you.
Thank you so much. And I just have to say, I appreciate the richness of your responses and nice to see so many familiar faces and new faces. And I really appreciate all of your perspectives. And I appreciate you keeping your responses brief too, because you have such rich information and stories. So thank you all. All right, so our next question is, can you please provide some examples for how you set a trauma-informed tone in your courtroom? And I believe Judge Tepper and Judge Reddy are to respond to this. So Judge Tepper, do you want to start since you're first on the list?
I can go first. One of the things that I've learned to do is, frankly, I take attendance. Because if, for instance, if I'm doing a juvenile delinquency court, an arraignment, and I have a mother whose child is on the run and has been reported, why do I need to have her sit there throughout the whole case? And or I see somebody that has a baby in their lap and different things like that. I find out who's there, and then we can start looking to see if there was proper notice. But also, it's important to see if I have somebody that is a victim and a perpetrator seated in the courtroom. And years ago, we changed it so that in any domestic violence injunction case, they are mailed in advance diagram of the courtroom, told who's going to sit where, so that perpetrators could not sit behind the victims and be intimidating them, and where everybody else is in the courtroom. Another thing that we do is I make sure I explain what we're going to do and who is who in the courtroom and how we're going to do it. And you can see people begin to relax because now they know what will be happening next. And then something else that I do is, for instance, in child welfare cases, everybody's getting a calendar. And I understand people have phones these days, but calendars, pens, information with local services, phone numbers, where they can go, and they can take it with them. And the courtroom is full of these materials as well that they can take with them. But in how I talk to them matters. And it's important also to remember them because they're going to be back in your court. And I used to make little notes on my computer about somebody just started a new job or this and that. So then next time I saw them, frankly, I was saying, so how's the new job going? Or focusing on how they're responding, and they're getting very irritated. Now my bailiff would know not to approach them and jangle handcuffs. I say, sir, what's going on? You having a bad day? How can I help? And then offer that they could take a break, or then with our liaison there from the health program, the mental health program, she could offer to go outside and talk to them. So you have to recognize that what you're seeing when they're exhausted or as they're talking, they end up telling you they have, I'm sorry, I have diabetes or this and that. It's going off in my head. Wait, these things are all associated with individuals who are living in a life that's filled with trauma. And then as you piece the case together, you begin to see that there is a whole lot more that's going on in this family than what brought them there. It may be because this 60-year-old man is accused of domestic violence on his wife, his son, and daughter-in-law with a little grandchild in the house. But then he ends up revealing that the reason he has all these telltale signs was he blurts out, I was raped. The 63-year-old man felt comfortable to say that, and I immediately could get my liaison to pair him with services, and it makes a big difference in then how the case goes. And it's just, remember people, make them feel valued, and make sure you're ordering those evidence-based services and that it's done promptly and that it's not going to be a burden on them to do too many things at one time. That'll take up enough time for now.
Thank you so much, Judge Tepper, for sharing those really helpful, concrete examples. Judge Reddy, would you like to share some of your examples?
Sure. I think the project I talked about before of having people meet with the social worker, the family court navigator, sort of sets the tone that we're trauma informed. Some of the other things I do is, because I'm only handling divorces, I don't allow anyone under the age of 18 to be in the courtroom. I don't want them to hear what's going on. So if they're brought to the courtroom because parents want them to listen, or because I'm going to do an in-camera, they are taken back to our jury room and they're given usually some very sugary drinks, not healthy, but maybe I should reconsider that. There might be some snacks back there, or, we've got coloring books and games so they're comfortable. We don't ever leave them out in the hallway where you've got, the criminals on the chains, or you've got strangers. So that we always keep them back in the jury room. The other thing that I do is I do a lot of in-camera interviews of children. I always do it in my chambers, not in the jury room. I don't wear my robe. It's very casual, relaxed. They sit on a really comfortable couch. They get to see, pictures of my children. I feel like it just sort of humanizes the process. And I think because I have 3 children of my own, it's just more of a conversation. I spend a lot of time just talking about them, not why they're here, but how are they doing in school and what's their favorite subject and what do they like to do. So they sort of become disarmed a little bit because we're just having a general conversation. I think it allows them to open up more about what's happening. So I think that's another thing that I do. And the third thing is, when we have court proceedings, most of my cases, they don't have attorneys, but whether they have attorneys or they don't, I don't allow the process to get too antagonistic. So when people start raising their voices, although every now and then I do it, I lose my patience, I sort of tell people, hey, we're going to calm down, we're going to be respectful, we're not going to attack each other, and try and focus on the positive. So those are just some of the ways I think like we've tried to change the process.
Thank you so much, Judge Reddy. Those are really helpful, concrete examples too. This is just such great, rich information. So just to keep things moving along, I think I'm going to toss it over to you, Kayleen, to facilitate question 3.
Yes, that is correct. And so this question, Judge Howard and Judge Tepper, you were going to address, which is, how much do you hear about trauma on the bench? Judge Howard, I don't know if you'd like to start, and then we can have Judge Tepper respond as well.
Okay. In the early days, it really wasn't much. Maybe if the defense attorney had taken some trauma training, they would acquire that information from the family and they would make a report. If the court had a system in place for screening and referral and assessment by a full mental health professional, then maybe there would be a report back from that. If you had a knowledgeable probation officer, they might incorporate that into their pre-sentence investigation. School personnel, if they'd been trauma trained, they might provide that information. Ultimately, what we would want to know is, have they suffered trauma? And was it a single trauma? Was it multiple traumas? Do they feel safe at home? Do they feel safe at school? If they've had treatment, was it successful? Are their family and caregivers supportive, or are they actually re-traumatizing the child? And what strengths do the family and the child have that we can perhaps build on? I usually didn't get that kind of information early on because the system was not trauma informed. But fortunately, juvenile judges have a lot of power to convene people and help build the system that can provide that information. The judge that was my mentor, Judge Reeder, he was a convener. And when I was his clerk, I watched him do that. He pulled the community together, and we had one of the first child advocacy centers in the country. The National Council of Juvenile and Family Court Judges always stresses the power of a juvenile judge as the convener. So if you are a judge and your community is not trauma informed, you can use that convening power to help make the community more trauma informed. And we've been talking about trauma-informed courtrooms and courthouses. That's necessary, but it's not sufficient in my view. Judge Tepper?
Well, it's interesting. It's sometimes when I hear it, it's when it's way too late. I've presided over about a dozen death penalty cases. And in every one of those cases, no matter how horrific the offense appeared, when the mitigation was heard during the penalty phase and the unbelievably hideous childhood was disclosed of that defendant, I did not have a single jury return a recommendation for death. And that was an eye-opener, although I didn't fully understand it then. And it's sometimes what's not been disclosed previously is what I end up hearing, because I made it a practice. In, for instance, delinquency cases, you can order a background report. We call them predispositional reports. In child welfare, a predispositional study. And there was a bad habit of only including prior reports that were delinquency and delinquency, dependency and dependency. And I got them to agree to give me all of the background, even if the call in for child abuse or other offense was not founded. And then I would get sadly, it wasn't unusual for me to see all these complaints for child sex abuse, and then it was withdrawn. And now I have a 15-year-old girl in front of me for theft. And I can still remember calling her, and I know what was happening. Mom was convincing her not to tell on grandpa or the boyfriend or whoever. And I remember calling her up to the bench one time and saying, by the way, I believe you. I believe you. I didn't see her back in my courtroom. But another example of that is that we because we don't dig deep enough, we sometimes don't realize that the person that's in front of us has suffered this trauma. And I had a deep end drug court. In other words, nobody funded it. And we didn't, in Florida, to deviate downward, we had to order all these background reports and things like that. And they would have scored to prison. But when I got those reports and I saw what they had begun to live, or saw, well, we put them through a program that had nothing to do with helping them. When we gave them the right services, then it became clear that we could help them, and they didn't end up violating. They didn't go to prison. I didn't get their children in court. So it matters. Do you hear about trauma? I hear about it, I read it, but sometimes I have to uncover it. And we should not be shy about uncovering it. And we have to make sure that the programs are evidence-based. You don't want a parenting program that isn't even considered evidence-based in California. You don't want to, you need prompt trauma assessments, and you need to make sure you're setting your next status hearing so that you can have that report and then make decisions that are related. And that's where you're going to see the trauma, but you have to expect to see it. In Florida, we say presumed trauma, and I urge you all to do that.
Can I interject for just a minute? Mm-hmm. I think what Judge Tepper, it's really interesting, and I'm going to try not to get on my soapbox, but I'm just such a big believer that this is why we ought to be putting more money into children and services early on, and how much would we prevent later on?
Absolutely.
It also, I think, raises the question as to, whether we ought to be rethinking, how do our family courts really work? I had a situation where I had a mom of 2 kids, and then her mom, some maternal grandmom, was, always getting guardianship. And it was a constant battle back and forth. It wasn't until 4 years later that I discovered what all the trauma was about. 4 years. And it's sort of one of those, you think, if they had been with professionals early on, they would have seen all of that generational trauma that could have been assessed instead of being in court and me trying to make legal decisions on matters that really weren't legal. They were very personal. So I just wanted to interject that.
100% agree with you.
Right. Thank you all for that. I really appreciate just particularly naming the community resources, as well as how this is a system-wide effort. I think that's really important and helpful to keep in mind. And so I'm going to pass it back to Cassie.
Okay, thank you so much, Kayleen. And before we move on, I just want to highlight a resource, Judge Tepper, you had asked us to put in the chat, and I just put it in there for folks to take a look based on some of the work that you wanted to highlight. So just to note that that is there for others. And we'll put in some links periodically as we move forward. Okay, thank you all. Thanks again for your insightful comments around the last question. And Tracy, I think you have slide control. Would you mind advancing to the next question? Thank you so much. So the next question is for Judge Reddy and Judge Howard. And the question is, do judges have to take continuing education about trauma? And regardless if they do or not, what is your perspective about trauma-informed training for judges? So Judge Reddy, would you like to start?
Sure. So we have trauma-informed education that's offered, but it is not mandatory. And so I suspect that it's mostly probably the family court judges that are taking a majority of the training sessions, but we're not required to. I believe we should. I feel like I've learned a lot from the folks at Northwestern, having gone through some of their training. I feel like the more conversations I have with people, I don't believe judges are really trained to deal with some of these things that we're handling. We're trained on the law. but not on the trauma side and not on the human side and how to deal with some of these issues. So I really wish that there'd be a bigger push for more of this training.
Thank you,
I,
Judge Reddy.
I would second that. I think it's not required in Ohio, I don't believe. I think it is perhaps in Georgia, but and perhaps other states. It's much more common now for judges to get that training. As Judge Reddy said, it is offered more. But it's not only judges. There are more actors in the system need to have that training too. School officers or school personnel, police officers. In Ohio, we have a Ohio Peace Officers Training Academy, and I think it takes about 100 days of 8 hours a day to get through that. And I think there's a total of, at least somebody told me, there's a total of 1 day devoted to child development and trauma. And you certainly hear stories about people graduating with JDs, with MDs, with counseling degrees, with school counseling degrees. They've never heard of the ACEs study. And they've never learned anything about the effects of childhood trauma. So more universal education about it, I think, would benefit everyone.
Thank you, Judge Howard and Judge Reddy. And I think I'm tossing it back to Tracy for the next question.
Yes, thank you so much. It's interesting though, to think about the comments that you both just made about the training, because I do think that, we have received feedback that judges are just so busy, right? And their calendars are so packed that it is legitimately difficult to incorporate this type of training. But it is interesting and helpful to hear from your perspective that regardless of that, it is still, at least in your opinion, considered something important and necessary to move the work forward. We are going to move on to question 5 here. Everybody's
And I
doing
would
good.
just, Tracy, before you do that, just encourage people to take a look at some of the comments in the chat from others, other participants related to that, where some are believing they should be required to, some, where it's in some ways, unfortunately, for banning using the word trauma in the court, which is really unfortunate to hear. But yeah, thank you for your responses in the chat, everybody.
Thank you, Cassie, for calling attention to that. So yes, all of our judges should feel free to respond to the chat either by writing or respond to each other. You don't have to be a judge to use the chat. And feel free to jump in and pause anyone from our team if you want to add any additional thoughts in between our questions. I'm going to go ahead and move on to question 5. And it is, in large jurisdictions with many judges, how do you support continuity or consistency across the courtrooms with regards to trauma-informed practices? Or stated differently, how do you collaborate with colleagues to ensure consistent practices? And I believe Judge Vahey, you may be up next.
Okay, great. Thank you. In Cook County, we have one of the largest unified court systems in the country, and we cover not just Chicago, but the surrounding suburbs in Cook County. So we have 14 total judges in the juvenile justice side alone, in a building that has half juvenile justice and half child protection. We are not a unified court system. And so this question just hit home because in this moment, as we are, and this is kind of inside baseball, but where we have a new leadership happening in Cook County, and there's a new emphasis and support of services in juvenile, and a new director being hired to oversee both the JTDC, the Temporary Detention Center, as well as probation. We're striving to make sure that all of the judges here are trauma informed and that their courtrooms are trauma informed. So it's not just the 14 judges, it's also the 14 to 28 sheriffs and the 14 clerks and the 14 to 28 state's attorneys and the 14 to 28 public defenders, and then the caseworkers who come in. And so the judge, in setting the tone, and often in my experience having to remind the people in the courtroom of the language and remind the policy and kind of do all of that, needs to be sufficiently trained. And so that training that's not mandated, I think, is now going to be a part, at least here, of if you're going to come to juvenile, you're going to have to be trained in juvenile practices, not just juvenile law, not just understanding the Juvenile Court Act, but understanding what the children we see have been through and how that impacts and why we see that. I can't tell you how often we see a child who on arraignment, I hear, has just lost somebody to gunshots or has just lost a father to homicide or overdose. And to think that that's not connected to the act we've just seen, is a grave mistake. And if people are working with children, they need to understand, the correlation between the trauma and what we're seeing. I also think it's important to remember that as judges sit and hear all of this and are trained to handle it, we also have to support each other in these spaces, because there are days where we hear profound stories about young people, from victims, about the case in front of us. And so we're also trying to incorporate a space for the judges to be able to be together and talk about their day and support the changes we're making. But it is a challenge, because in smaller jurisdictions, if you can find one person who's vested, check, you're done. But we're right now in the process of trying to make sure that the people who choose to come here and want to come here are in agreement and trained and working together to maximize trauma-informed practices.
I'm not sure why I volunteered for this question. We had 3 judges and 6 magistrates. I didn't know I paired up with Cook County. So I don't really have a lot to add. But I think basically what I did was just nag the other 2 judges about what was important until they finally surrendered. But if you can agree on policies and procedures and get those things so if they're institutionalized and they're going to be there after people rotate out or leave, I think that's critical. That's about all I have to add.
Thank you both very much. And Judge Vahey, coming from, having worked really closely with Cook County for several years now, that is all very exciting.
It's very exciting right now. Yeah, in Cook County.
Okay, so I'm going to pass this off to Kayleen. I think you're up next. I'm going to move the slide for you.
Thank you. So our next question is there anything you need from other professionals to help with trauma responsiveness? And Judge Howard and Judge Tepper, those are questions that you wanted to address. So this time, Judge Tepper, do you want to go first? And then we'll pass it off to Judge Howard.
I'm not on question 6, Judge Howard,
Okay.
Judge Bonfiglio.
Oh, okay, Judge Howard, go ahead then. And then Judge Bonfiglio, do you also want to respond to this? You can.
Okay,
Sure.
I would start. So, is there anything that you need from other professionals? I think one really important thing is for defense attorneys to do a thorough job of presenting to the court facts about trauma. Defense attorneys need the training, they need to understand, they need to inquire of their clients. And again, that list I went through before, single or multiple traumas, are they safe at home? Are they safe at school? Do the families and caregivers support, or are they re-traumatizing? All those things are important for the court to hear. And after the hearing, the attorney needs to have enough time to sit down with the family and explain in detail what happened. The family's under a tremendous amount of stress in the hearing. The attorney understands what happened, but too often they go out in the hall and the attorney rushes off to another hearing. And having given the date for the next hearing to the people, and they get no explanation. That was something I learned when we campaigned. We were elected to our positions, which I'm not sure is the greatest way to do it, but I did learn an awful lot on the campaign trail. And one of the things I learned when I met people who had had hearings was I never knew what was going on. My attorney didn't explain it. I put great stock in information from the schools. They have the kids, 6 or 8 hours a day. They know the kids really well. And mental health professionals. A defining moment in my career, we had a young boy who was he was developmentally delayed, and he had a sexual incident. He was in the multisystemic therapy for problem sexual offenders, and he was failing the program, wasn't doing well. And they came back to court, and the recommendation was he needs to go to an institution. And everybody was unified in that recommendation, and we gave him his chance, and he can't handle it in the community. And there was a psychiatrist sitting in the back of the room that I knew was an advisor to the program. And I asked her if she wanted to say anything. And she said, it's not surprising to me at all that he can't get through this program. He's not mentally capable of doing what they have him trying to do. But she said, I can modify this program so that he can do it if you'll give me a chance. And had she not been there and had she not given me that input, I'm quite sure that I would have institutionalized him. So that was a watershed moment for me.
Yeah, I would certainly echo Judge Howard's thoughts there. And I I would say most, tell us what we need to know. Don't be intimidated by the court process. As the other professionals should give us, clear, concise information. I've made it a point in my career to go out to talk to all our mental health providers. I was involved with a school board member for many years. Education, we've always had representatives in our courts from the schools. And I would say, I invite all the mental health professionals and other professionals working with children to come to court. Don't be intimidated by the process. I always ask them for their input. So I'd say just give us the information we need, give us in-depth information. Don't be intimidated by the court process, us as judges or the court process.
Thank you both. I appreciate that. And Tracy, back to you.
Thanks so much, everybody. We are doing great, and you all are just killing it on the timing here. So please feel free if anyone's wanting to jump in and answer a question that has not been assigned to them. And then the worst case scenario is if we finish a few minutes early, we will absolutely be able to take some of the questions that folks want to put out there spontaneously and or just reflect freely. So I'm going to go ahead and start with question number 7 here. I believe Judge Vahey, Judge Tepper, and Judge Howard are up for this question, if you all would still like to do that. So the question is, for trauma-impacted youth who've committed very serious offenses, how do you keep a trauma-informed perspective, especially when you are considering detention or jail?
So we have many very serious cases with juveniles here in Chicago. And when the children come in on the first court date, one of the first things that happens in the process of arraignment and detention is that all the facts of that incident are repeated. So I tend, as indicated previously, to believe, in my experience, even know that every child who appears before me has been traumatized. But if they weren't before this incident, then even although a perpetrator, that is a very traumatic series of events. And so we have just recently had an incident, and then you're standing in front of a courtroom under neon lights listening to the facts read back to you in front of a guardian or parent. So it's hard to not be aware of the trauma. I think in how we run the courtroom then becomes very important. So I always tell children what's going to happen next, because I too went to a conference where a person who had been in juvenile court said, I never understood what was going on. And so I use language that's appropriate for children, not just a courtroom, and tell them, here's what's going to happen next. I'm going to tell you about the charges. I'm going to listen to the state's attorney give me a summary. I'm going to decide what happens next. And so in that process, they're, as much as they're able to listen and understand, we try to support that. I think the sheriffs that we have work here consistently with children and know the children in the same courtrooms that the sheriffs are permanently assigned, that helps, because they're very good at what they do and working with children specifically. Here in Cook County, children are processed into the detention center before they come to see us on a new case. And so that's something we're trying to address, because that process in and of itself is traumatizing, and children are given a shower. We're working on planning on those children coming directly to the judge during the day. And I've thought a lot about whether or not, although I realize that I think that's preferable, but if we have children in a courtroom and they're about to be detained and they haven't been processed in, how scary that can be to a child who doesn't know what's coming next and what to expect. And so what we're working on as we prepare to bring kids directly to courtrooms and not process them first are pictographs for children of exactly what to expect in the process, which include the police station and being brought to the courthouse and being brought to the judge. And then when they're brought upstairs, what that looks like. I was recently at a conference in Northern Ireland, which runs a very impressive juvenile justice system as a result of their the troubles in Northern Ireland and the 1998 Good Friday Agreement. They had to redo the juvenile justice system, all justice systems, because there was no faith in the system. And that country is a country who supports the rights of children. And so they use pictographs a lot. And I'm hoping that in all of the ways that we can prepare and inform youth for what's about to happen and what they can see coming, that we can help usher them through that process as they come in. Because sometimes these children frequently are detained. And then we need to make sure that the detention center where they're being detained is trauma informed and is doing the best they can with the children detained there.
Excellent. Thank you. Judge Tepper.
Yes. Let me make sure that if your juvenile detention center is not trauma informed, see if you can get them and the caseworkers in juvenile justice to talk to the head of the secretary of that department, get them trauma informed. I was pleased that our juvenile detention center was so trauma informed that kids didn't want to leave. And they had more GEDs than any other juvenile detention center in all of Florida. We were in the rural west part of Florida. But when juveniles were in front of me being considered to be held in detention because of either their history or the nature of the offense, I always read the backgrounds, and they learned that I needed to have the background on this child a little bit more than just superficial. And I could read some things that were sometimes suspicious that there was more going on in that home than meets the eye. But so then I would, and by the way, when I had the amazing honor to meet Dr. Folletti and get him to come teach all the judges in Florida, I had asked him, I said, is it harmful for me to start raising these issues with parties? And he said, no, you can do it. And so I'd say to the kids, without going into all the details talking about sex abuse or anything, I say, sometimes bad things happen to kids and it's not your fault. And sometimes bad things happen to your brothers or sisters and it's not your fault. You couldn't have saved them. And I might have read in a report that one of the kids got sent to a grandparents out of state every winter or summer or whatever it was. And I'd start to see the tears on these kids as I was talking about bad things happening to them. And I'd say, because we had a trauma-informed JDC with a fabulous therapist there, I'd say, I can arrange for you to speak to somebody. How about I do that? And I'd see heads nodding, and I would write it right into the detention order, and they would immediately begin to get some trauma-informed care. When juveniles were sent away and in a committed status, and yet they didn't seem to be making any progress, in 2001, when I had one of the early unified family courts in Florida, I didn't know about trauma, but I was seeing it. And we had a case where the juvenile had been in this program for so long, but he was never moving beyond part one, that first stage. And he indicated to his public defender that he had siblings that had been lost through child welfare. They had been adopted out. They had ended up in prison. He didn't know where they were. And he wanted contact. And so we got the information on his brother in prison, got permission from the prison for him to communicate with his brother. The caseworker reached out to the adoptive family and let that sister be able to speak to him. And better than that, his public defender found out that there was a school teacher that this fellow was very attached to and had him come and connect with that young man. And then he started visiting that young man at his program. And guess what? That individual from school, he had been in the system when he was a kid. And when we got the next report on this young man, they said, in these 3 months, he has made more progress than he has the whole 9 months that he's been here. And it's because he has a judge that cares. But it wasn't just me, the others were working on it as well. And so you have to keep looking beneath the surface, even if they're already in a committed program. And the other thing I always do is I write letters to youth. I'll get a report in a committed status. In other words, they've committed enough crimes that they've been sent away, and I hear how they're doing. And I'll write back and say, oh, it's really great to hear that you did whatever it was that he'd succeeded at, or she. And then I'll say, in the part that they hadn't yet, I say, and I can't wait to hear about your progress in the next report on this area. And I would just do that regularly. And we had one of the programs, a fellow that worked in the program wrote me and said, Judge, whenever you send the kids letters, and this was, again, long before I knew anything about trauma, he said, the kids run in and show me the letter. They're so excited that you wrote them. It matters. And suddenly they matter. And it makes a difference. And just because they're a deep end doesn't mean they're going to stay there. And we can help bring them out with this what I consider positive attention and looking deep.
So anytime you have one of those really serious offenses, you tend to go back to the dual mission of protect the community and rehabilitate the child. And on a serious offense, it's always a great urge to stress the protect the community part of that, because no judge ever gets in trouble for locking somebody up. But if you don't lock them up and they do something else, then you're going to get a lot of negative publicity. And so one of the ways that you can help avoid that is to use an evidence-based risk assessment to give you some idea of whether you should be locking them up or not. But again, there's a tendency to maybe want to overlook that. We'll just put them down at the detention facility. It won't hurt them, and maybe they'll learn a lesson. And in Ohio, we had the state commissioned a study by Dr. Ed Latessa from University of Cincinnati on the effects of detention on kids. And the study came back very definitive that if you put low-risk kids with high-risk kids in an institution, you actually are going to hurt them. They're going to come out, the low-risk kids are going to come out much worse off for that time. So that was a very sobering, I think those results were presented at a judicial conference, and that was a very sobering session. So I think the risk assessment and sticking with the risk assessment is important. But I would echo what the other judges said. If you're going to have an out-of-home placement, detention, or some other facility, hopefully they've had some trauma training, because you don't want to put the kid there if they don't. You want to think about, is the child going to be likely to be triggered there? And then you have the sort of the dilemma of, if you know what the triggers are, do you communicate those to the placement? Because it can be very helpful for them if they know what might trigger the child. But it also creates some vulnerability, because if somebody gets crossways with the child and they know what triggers them, it's going to be a lot easier for them to met out some punishment against the child. Okay, that's it for me.
Thank you, Judge Howard. So we're going to go ahead and just move on. I'm going to take this next question as well, question number 8. And for question number 8, we have Judge Reddy, Judge Tepper, and Judge Vahey who are going to respond. So question number 8, are there any immediate supports, anything that you or others can do for youth and families who have trauma responses during the court proceedings? So Judge Vahey, would you like to start us off?
Sure. This is where you need the whole courtroom and the staff trained, because I think when you see the mood or feel the mood in a courtroom start to shift, or if you're paying attention, you can see that things are not going well. There are things you can do before you get there. You can stop the proceedings, you can pause, you can separate parties. Sometimes we have to speak to a parent separate from a child, or a child separate from a parent. There are very frequently people in the courtroom who I would trust to take a child outside, a teenager, and speak with them and then come back and report the situation. I think on cases where you expect or have had this problem before, you can have conferences with both attorneys present so that you're aware of where things are. And then we have here in this courthouse family navigators, and that's been mentioned before. They work through probation, but they are with the community. They've been hired through probation, but they're community based. I'm not saying that clearly, but they are lived experience people who have themselves or their children been through the process, and they are available every day. And that is someone also who we can rely on in addition to the probation officers and other staff to help and pause. I think you have to be creative, and sometimes you can't do things in a regular way if you want to be aware and if you're practicing trauma informed in a courtroom with children.
Judge Shepard, please feel free.
For instance, if I have a contested hearing, and believe me, by taking a trauma-informed approach, you're not going to have a lot of contested hearings because you get people that buy in, and then you're starting to get them services early. But at any rate, I had a case in which a juvenile was going to have to testify in a domestic violence injunction against her cousin who had molested her. And I had gotten the attorneys to agree that I was going to have a therapy dog in court. And of course, nobody else would be in the courtroom. And what happened was that therapy dog was up in the witness stand with this young lady, and the handler was basically flat against the wall trying not to be there. And when a question was asked, the little girl would get down and pet the dog and then sit up and answer the question. And we went through this the entire time, and she made it through the process. It was very effective. Fortunately, only happened one time. Another thing is that the therapy dogs are there at arraignments. They're there at a variety of other, when we have pre-trials, all the juvenile cases. And we, in Florida, we're supposed to have the children in child welfare cases unless there's a good reason for them not to be there. And the children look forward to the dogs. In fact, if I didn't have a therapy dog there, they would say, how come the dog isn't here today? And we had, it was a former attorney who had taken on, when she retired, started training dogs, and as she organized them, and so they would have a schedule to come in. It was such a positive atmosphere, and it reduced the stress for everybody in the courtroom, not just for the youth. And of course, I'm a great believer in just, if somebody's having a bad time, you say, what's going on? How can I help? And then having that mental health therapist or the liaison there was a huge help, who could immediately get some assistance or pull them outside and talk to them, take a break. And then on the sweet side, but it mattered, the stuffed animals, and we had quilts. We had women in the community that made quilts that gave them to us, and we could give them out to people. And so, it's trying to give somebody a little calm. And I had a juvenile in detention center. I gotten permission to give all the kids quilts, believe it or not. And one of them didn't have one. And she'd been in a lot of detention centers, and she'd had a lot of attitude. And I said, well, how come you don't have one? And she said, well, I'm leaving tomorrow. And I said, no, I've checked. You can take it home with you. I can. And we gave her the quilt, and she started petting it like it was a puppy. And by the way, years later, I'm still in touch with her, and she's doing extremely well. But I'm not saying that was the difference, but the combination of the trauma-informed environments and the approaches, not just of me, but in the detention center, in the juvenile justice center, in child welfare, it matters.
Yeah, it's more than the quilt. It's the court showing that that person is a person, no matter what they've done or why they've shown up there. Judge Howard. Or have I got you wrong? No, I'm sorry, Judge Fahey. I just glanced down at my paper wrong. My apologies. Judge Fahey.
I think I did this.
I think you're waiting
spoke
on
to
me.
this.
Judge?
Yes. Yes, Judge Reddy, there we go.
Judge Reddy. Goodness, I took my readers off. My apologies. I'm so sorry. Please, Judge Reddy.
And so I don't have as many of these resources as the other two judges have talked about. I think for me, a lot of it is paying attention to what's happening in the room and people's body reactions. You know, sometimes when we've got situations where, you know, there's been domestic violence and you can see one person getting very uncomfortable. We don't typically have security in the family courtroom, so when I can sense that somebody is getting nervous or scared, then I will have the staff ask security to come to the courtroom, and that usually at least ends up making that person feel safer for that moment. The other thing I have is for all of our divorce hearings, our family court navigator participates. So she does it by Zoom because there are so many. So she's always available. So if someone does have a response, she's on the line and I can say, listen, we need to get them into services immediately, and she can usually do that promptly. So those are the two avenues that we have.
Fabulous. Thank you. Cassie, I believe I'm giving it over to you.
Correct. Yes. And we are winding down our time. So thank you everybody for bearing with us. For question number 9, if you wouldn't mind advancing, Tracy. I believe this goes to Judges Bonfiglio, Howard, and Tepper. What suggestions would you have for other judges or other justice professionals who want to have a more trauma-informed perspective? Judge Bonfiglio, would you like to start?
Sure. One of the things that I really appreciate, I have a bench card from the National Center for State Courts. It is wonderful. I keep it on the bench. I often look at it. I mean, there's things I forget, and it just reminds me on a daily basis of how to be trauma informed. The National Center for State Courts has wonderful things available. This is, you know, completely without any cost. They have a number of trainings available. The National Council of Juvenile Court Judges also has trainings, but this is a real practical thing. I just keep on the bench, look at it all the time. It really helps keep me focused on being trauma informed and understanding what's going on in front of me, because that's my major suggestion.
Thank you so much, Judge Bonfiglio. Judge Howard, would you like to go next?
Yes. So I'm going to talk about something that's near and dear to me, and that is the trauma-informed juvenile court self-assessment. I want to give you a little background on this. In 2016, the National Child Traumatic Stress Network called together a group of stakeholders and had a conference on with the theme being what makes a trauma-informed juvenile justice system. And they came up with 8 different domains. And I'm going to just briefly go through them with you. One is having trauma-informed policies and procedures, identify and screen youth who have been traumatized, have clinical assessments and interventions for the ones who are identified in the screening as having issues, trauma-informed programming for your staff, trauma training for the staff at the court, prevention and management of secondary traumatic stress or compassion fatigue among the staff. And one of the other judges mentioned that the staff sees these things every day. They hear these stories every day, and just like the judges do, and it affects all of us. So managing that and having some relief for that is important. Trauma-informed partnering with youth and families, trying to put them in a position where we can look at their strengths and then put them in a position where they can use those strengths to help solve the issues themselves. Trauma-informed cross-system collaboration, I've already talked a little bit about that. I mean, all the systems that serve kids need to be involved, especially the schools. I had just a handful of kids over all the years that I was on the bench that had good school reports. Almost everybody was not doing well in school, and I came to believe that that was primary prevention. If I could get those kids to be successful in school, there was less likelihood that I was going to see them again. So I think the schools are, very important collaborators. And then trauma-informed approaches to addressing disparities and diversities. You have disparities in the system, and it's important that we recognize that and address it. So a group of us then took those essential elements because we had courts asking us, well, okay, I understand trauma is important. What do I do about it? And we took those elements and then developed the trauma-informed juvenile court self-assessment, which goes through each of those elements. It's really a way to review and evaluate those essential elements. And it's a framework to promote adoption and sustainment of trauma-informed practice in the court on a day-to-day basis, and really just a template for what it means to be a trauma-informed court. We piloted among 3 or 4 courts. We did a journal article in the Family Court Journal about that. Cassie and Tracy and their team have used the instrument in working with Cook County. So those of you from Cook County are probably familiar with it. And basically that was a facilitated approach. We called it the trauma-informed juvenile court self-assessment, and we tried to design it so that courts could do it themselves. But we came to realize, especially after the work that was done in Cook County, that having a facilitated approach was a better way to help courts go through the system. So we're working on a facilitator's guide to take courts through that. We have several courts that are already have already signed up to go through the process, and we do have open. I just checked yesterday. We do have openings for more courts. If there are courts that are on here that would like to avail themselves of that, you can. We've got this QR code up that will lead you to be able to contact people to go through that. If that doesn't work, you can contact me, or I think we put Riley's email is down there at the bottom, and you can get a hold of Riley Thorough, and she can send you in the right direction. I'm very proud of this instrument. I think it really is an answer to what do I do now if I want to be trauma informed. Thank you.
Thank you, Judge Howard. And Judge Tepper, I'm gonna let you round out this question, but just to note, we are almost at the top of the hour. So
I understand that.
If the judges panel wants to stay on for a few extra minutes, or if people need to hop off, but yes, like Judge Tepper, please take it away.
But on that last question, I recognize most of the people on this are not judges, but that doesn't mean you can't access the sites that have been mentioned by everybody, and they're on. Some of them are in the chat. Go ahead and take a look at them if you want to become educated. And also, there are things called audits or assessments, and why not you walk through your office and see and ask? Maybe you want somebody from a domestic violence center, maybe you want a therapist to walk through and see what it is about your office that may be triggering. For instance, it drove me crazy that the mental health program used to do mass intakes at 9 a.m. Wow. Do you think people really want to sit together with a bunch of other people in a mental health clinic? No. And so do that. That simple. Take a look at what you're doing, read everything, and why not you be the one to approach the judge or approach another discipline and say, let's get together. Let's invite somebody to come teach us so we can do a better job. So, there you go.
Thank you so much. Thanks for keeping that brief, Judge Tepper. Tracy, back to you for how to round things out. I know you want to touch on the final question if possible.
Yeah, I think that Kayleen was going to be up, but we're at the end here. So as Cassie said, if anyone does need to leave, we thank you for having been here very, very much. We hope that you will fill out the evaluation. And then if any of our judges, if you're able to spend a few extra minutes, maybe we'll kick off with Judge Vahey. Are you here?
Sure. Yep.
Okay, so Judge Vahey, if you would like to start us here, since you're our Cook County star, that would be fabulous. Thank you.
Sure. I do think that there are barriers. I think that there's a lack sometimes of true belief or buy-in that trauma can be connected to criminal behavior. And the way to address that, I think, is training. There is a book that is not courtroom based, but one that I read in learning about some of this called The Body Keeps the Score, that tells the story of a Vietnam vet. I'm seeing so many nodding, but it's not a matter of, you have sympathy for someone because you feel bad that they've done this and now they're sad. There is real hard science behind what we're saying here, which is that children who've been traumatized and are acting out accordingly, or following up with that's a real phenomenon, and that if we can address it equally informed, that's best for them and for the safety. So I think that requires, really being specific about who are the judges and the staff we put in these courtrooms, and how sufficiently we train them about the realities of what trauma really means and what it looks like.
Judge Reddy, would you like to weigh in?
Because my trauma-informed practice is so much more focused on the screening and the assessment and the services, it really requires a lot of financial resources. And trying to get those financial resources is a barrier. We will write so many different grants. I've really focused on getting a lot of funding from our county council, and we've been really successful the last couple of years. So that's really the biggest barrier, is finding the financial resources and convincing people, like Judge Vahey said, is that this really does work. There is a connection between trauma and criminal activity, and there can be a positive connection between screening individuals early and getting them services. There's just so many people who just don't believe in the effectiveness. And I think when I went before, the county council recently, some of them are like, well, we don't really know if this works better, or, does rehabilitation, from jail work better? And so I think sometimes it's really hard to convince people that early intervention is the key. So I think those are some of the biggest barriers.
And then Judge Howard, were you wanting to close us out?
No, I don't think so. I did. I was concerned about being able to talk about the trauma-informed juvenile court self-assessment. Oh, and I did forget to mention on there, the National Council of Juvenile and Family Court Judges also does what they call a trauma audit, where they will come and be on site at your court, observe what's happening, and then write a report with suggestions about how you can be more trauma-informed. And we're currently sort of partnering with them with the trauma-informed juvenile court self-assessment. Maybe start with the audit and then come in and do the self-assessment.
It's an eye-opener. It's wonderful. I had it done.
Thank you for making sure to mention that. Just want to extend one last thank you to each and every one of these 5 amazing judges for being here today. There were quite a few really interesting commentaries and questions put into the chat that we're at the end of the hour, so we don't have time to get to today. But maybe we can come back at it at another time. I did notice that one of our Cook County colleagues pointed out that we didn't talk much about vicarious trauma. I know that it was mentioned, but that probably would have deserved a whole lot more attention. So I'm sorry that our panel hadn't come up with that.
And some of that information is on the Florida website on vicarious trauma and ideas.
Fabulous. Thank you so much, Judge Tepper. So thank you all for being here today. Do any of our judges have anything you want to say before we end today's call?
Thank you for coming and listening and caring and doing the tough work.
All right, then. Well, we wish everybody a wonderful rest of your afternoon. We will hang back just for a minute, and then I'm going to go ahead and close out the meeting. So thank you, everyone, for having joined us today.
Thank you.
Thank you.